Like, okay, you got away, and then you came back. And I was like, oh well, you have to escape when you can.
Yeah, okay, I've had a few hard sales pitches.
Hey guys, how's it going? Good.
Yeah, I was kind of borderline duress, and so I can't sign here.
I'm in Barbary.
I'm not very close.
Are you a rep?
I am. Yeah.
For
Chapel.
okay.
You're a barber, right?
Yeah. My friend Art and Alexis got to me early.
Yeah, once the showdown.
What, the discount showdown?
I know, they are. They're just like... And you finally got her to say that after her, like, talking at you for, like, 10 minutes. You were like, they're basically the same. And she was like, no, they're not. And then, like, yeah, they're basically the same. And I was like, I can't believe she pulled it.
Yeah. I will not weigh in on the issue you all are discussing. All right, let's check in with our guest speaker schedule. So we have Justice Marquez on the 11th. Will you guys be coming from school or
Work.
Okay. I'm just wondering if we'll figure out before that whether we should carpool or something. And then Alex and Kevin are coming on the 8th. Judge Jones is on the 15th. Is that confirmed? Okay. Oops. Great. I'll work on filling in our other two spots. Bill, I think, is stuck in another city.
Oh no.
Yeah, so don't think he'll be able to join us today.
I'm sorry, did you say that 8th and the 15th?
Yes.
Okay. Aren't those Fridays, or am I going crazy?
April.
Oh, April.
Oh, okay. I was
I've done that. I mean, I've done that before. I've created a whole syllabus. A little bit off. Yes, in April.
Okay.
In April.
Okay, I do have those on my calendar. Thank you.
All right. Okay, so we're in the process now, right? We're reading this stuff, but we're reading all this stuff, all the materials from the cases, toward the goal of drafting your, United States Supreme Court decision. So the materials you have so far are the district court decision, the United Circuit decision, petitioner's brief. And what does petitioner refer to? What does that mean? Why do we call them petitioners?
They lost in the Ninth Circuit, so they petitioned to the Supreme Court.
Okay. And then respondent's brief. And I brought copies of that today for you guys. Yeah. Okay. So this is the opening brief. This is the answer brief. And then petitioner gets a reply brief. Then we're going to have oral argument, which I'm just incredibly excited about. So Professor Smith and I we didn't file, we just sent it to the printer, but an Animus brief in the DOMA in the Windsor litigation. So we're trying to see if we can get to Washington and get tickets for the oral argument, but we'll see.
Do they post those online?
They would post the transcripts online.
But not the filmed oral
The
argument?
day up. No. I don't.
Behind the times.
Yeah, I don't think they might do audio. Yeah, but they don't allow film in the United States Supreme Court. Is my understanding. And then case law, I don't want you guys doing a ton of outside research. And what is interesting to me, since I started teaching this problem 5 years ago, there's really nothing new under the sun. I mean, there's basically the sort of core equal protection cases, and then there's the body of law specifically on same-sex marriage. But it's not as if there's some undiscovered treasure trove of case law precedent that applies to this issue, right? And so for you all, I really don't want you overexerting yourself in terms of doing independent research, but more I want you to think about what cases are. You really could choose one case, like the Ninth Circuit did, to model your decision after, right? So Romer is one choice. Okay, Loving is one choice. A lot of talk about there. Maybe even Brown. Claiborne. We can brainstorm other cases too. But this is the universe of materials that you're working with, okay? And I wanted to check in with you guys about how your terms of summarizing the lower court decisions, how that's going. And you don't necessarily have to have worked on it since.
I started, it's difficult.
Yeah.
To boil it all down.
It is. I mean, so actually summarizing longer pieces of material concisely is a really difficult and really important skill. So we could talk about that some more today if you want to. Any other comments or feedback on that effort?
I started, but I kind of decided to hold off till I knew how I was going to do it.
Okay. So one thing, and I want to talk to you guys about this because I think in some ways I'm imposing my writing process on you a little bit, but this is also, this is something I've done just to create, just to get the ball rolling in terms of writing. If you have writer's block, with the amount of writing I had to do for the courts, less so in private practice, honestly more for the courts, writer's block is just not an issue anymore. It's like chopping wood, basically. It's like you go in there and you just, and sometimes it's really, much more engaging and exciting than chopping wood, but you kind of start by chopping wood, right? And that's still kind of my practice, whether it's scholarly writing or writing a brief or what have you. To write description, fairly objective description of the base materials, the raw materials, if you want, recognizing that description is going to transform by the time I get to my ultimate work product, right? So I might have a 4-page description of the district court decision that becomes a 2-page narrative that kind of characterizes the decision and highlights key points, et cetera, et cetera. So just kind of distinguish between, so it's totally fair if you don't really want to write it until you have more of an idea where you're going with it, but don't underestimate what you will learn by writing it before you know where you're going with it. Okay, so, for example, in talking about the Ninth Circuit decision, as you work on describing it, you might say, wow, I really have a problem with this reasoning. Or, I think this reasoning is right on. So your insight about what you actually want to say in your opinion that you're drafting might come from that process of describing the raw materials, okay? Same thing goes for the briefs and for any case law. So again, whether it's writing a brief or writing an article, I will just write descriptions of the case law until I sort of figure out what the theme is and what I really want to say about them. So you obviously have your own process. If you're open to trying this, I think you might find it advantageous. You get some passages. Well, you're also practicing writing and finding your descriptive voice. You're getting some passages down on paper that you can use then in your decision, and I think it really facilitates this whole thought process. And you also, that's how you become an expert in the case, right? It's not just reading everything, but actually writing it up, and it sort of embeds that knowledge in you in a different way, okay? Any questions about that process or that idea? Okay. And so really that's sort of the universe of information that you're going to be working with.
Actually, I do have a question.
Of course.
So you kind of skip from writing an objective description of the base material, so lower court decision, but do you do that with all of the briefs too, and the oral argument, or do you go straight from the lower court decisions to the case law?
I would do it with the briefs as well.
Okay.
I mean, we're going to talk about the briefs today, the themes in the brief, and also the content of the briefs, mostly on the opening brief today. But oral argument is different. Oral argument is more chaotic. You know, I don't know if you guys have read a lot of transcripts of oral argument before the Supreme Court, but it's really, you know, sort of 9 cooks in the kitchen. And I wouldn't probably go to the effort of describing the entire thing, but more there, I think you want to select sort of key passages that really stand out. Like this, I don't mean to keep talking about my scholarly writing, I guess I'm thinking about it a lot because I'm doing some right now, but the piece on the affirmative action case before the court, Fisher versus University of Texas, that I wrote kind of, there was just one passage in the oral argument where it was really clear that the justices were kind of confused about the justifications for affirmative action, and so kind of focused on that and then used that to launch the larger discussion in the article. Here, when you're writing a decision, I think looking to oral argument is going to be just more of a sort of a source of ideas for you guys and sort of a clue. I mean, I can't wait till oral argument because that's the first indication we're going to have about what the justices are really thinking. Are they going to ask questions about animus? Are they going to ask questions about sexual orientation as a suspect classification? So long answer to your question. I would do a description of everything, except with the exception of oral argument. That's going to be more just a source of information for you. Okay.
I have a follow-up question about
Yeah.
words. So, in terms of how, like, binding what the attorneys say at oral arguments is, like,
On whom? Binding on whom?
Right. Well, that's kind of part of my question.
Okay.
So, on them, I guess, in terms of it being an argument. So, obviously, the writing that they submit to the court is their, like, official position, but provided that they, like, elaborate on it or even contradict themselves in oral argument, what is...
The only thing that's really, I don't want to pretend that I'm answering this in a technical sense, it's more just sort of like intuitive based on the oral arguments I've seen and how they work, is waiver, right? So you could abandon an argument, you could waive an issue in oral argument. You'd have to, but you can't sort of do it inadvertently. You know what I'm saying?
Yeah.
And it really would be odd. You know, it'd be like, okay, counsel conceded an oral argument that the appropriate factual record for us to consider here was X, Y, or Z. So I guess you could have waiver or concession. This pen's not working, which is why I'm making Marge Simpson noises. But it has to be it's a pretty overt act, if that makes sense.
Okay.
So, you know, if there's a little bit of sloppiness in terms of oral argument versus what's in the brief, that's not going to, you know, be held against the party. No. But the court can back an attorney into some sort of concession if there's an issue. You know, I mean, why do we have oral argument? It's not to rehash the briefs. What's the point of oral argument?
Clarifying resounding issues.
Yeah.
Is it your,
Well, so that's the point for the attorney.
judges.
Well, what's the point for the judges?
Pick at the weaknesses, I don't know.
Okay, so you think there's a weakness or something missing in the argument, so you want to reveal that? What else?
I mean, also the strengths then.
So the judges will sometimes use the attorneys as like avatars, right? So, I mean, this is one of my favorite moves that judges make, and it's something, I don't know. So, you know, in your first year when you have oral argument as part of your lawyering process class or whatever, I've been a judge for that for a few times, which I really enjoy for obvious like ego gratification reasons. But one of the things I really like to do, because judges will do this, is throw a softball to the attorney, because you are trying to get them to articulate what you think is the winning theory of the case. And, you know, attorneys sometimes catch and run with it, and other times completely, you know, bobble it or whatever. But so you see that a lot. So the judges may want to explore both weaknesses and strengths in the argument. What else? Who are the judges communicating with during oral argument? Primarily the attorneys? Who else might they be communicating
Each
with?
other.
Each
They
other.
could be battling it out
Yeah,
with each other.
okay. So the lines of battle may already be set. And they probably are. So, you'll see the judges kind of focusing in on what are particularly decisive points, determinative points with respect to the case. And unresolved issues, questions that the judges have, where in the record could I find support for this? Are you really saying that this case stands for X, Y, or Z, what have you? So it's going to be interesting.
Okay, so here's a follow-up question about that then.
Yeah.
If the judge asked, or one of the justices asked an attorney, like, are you really saying this? And they've said something different in their brief, but then in oral arguments, they're like, yeah.
Right.
Not that they would be
Well,
unprepared,
but
but
that's-
if
that's-
there's any contradictory, or if they put forth like a new rationale or something that's not in the brief, like how much weight does that get in terms of writing a final opinion?
So two issues. One is kind of almost like a preservation issue, which is that you can't advance a totally new theory coming out of whole cloth at oral argument, but you might give a different emphasis to a particular theory. But I think the weight that's accorded to it really depends on the agenda of the judge.
Okay.
Unless, like I said, they give, they back the attorney into a corner where the attorney has to give up a particular point.
Yeah.
In terms of, what the record says, but maybe what a case stands for. But again, people can disagree about what cases stand for, so it's not as black and white as you are now bound by the position you took at oral argument.
Okay.
And this is frustrating, but, experienced advocates will be very careful not to make concessions and be very, very cautious in how they answer the questions. But, like they always say, the judges are not there for you to make the song and dance and persuade them.
Yeah.
They're there to have a conversation with you, right? And they really want to kind of get to the bottom of it and have you help them with their thought process, ideally.
Because I've definitely seen some oral arguments where a justice will back the attorney into a corner and say, yes or no, is this what you're saying? And they have to say, like, yes or no, and if they try to get around it, then they, And so it's interesting because maybe in their brief they've gone on for 10 pages about, both sides of whatever issue it is, or, what they consider to be most convincing, but when you have to boil it down to yes or no, like, I don't know, it seems...
Well, that's why there's that sort of truism that you can't win an oral argument, you can only lose. All right, because there's a lot of obfuscation that goes on in the briefing sometimes, so you want to be careful about a particular point that you make. Okay, so that's the process point. Okay, we are gathering our raw materials for the decision. I advise that you write descriptions of these raw materials, recognizing that you're going to sort of edit it later, but that will really help get you deep into stuff. It'll plant it in your memory more so you can work with it with more facility. And we want to be thinking about the case law and where you're sort of, what you're leaning toward. So let's talk about the petitioner's brief. I actually was really impressed. I was really impressed with this, which I hadn't been originally by the table of contents, because the table of contents, I didn't think the headings made a lot of sense, and they're not pursuing equal protection analysis the way that I think they should pursue it, or the way that I think they should lay it out. But I think what they've done some really smart things. So let's just actually look through the components of the brief, right, since you guys are all going to be working for the courts. So you have your cover page with the the case information, obviously docket number, things like that, which tells, in a more mundane sense, really, tells the clerk where to file things and how you manage your docket at the court. So, for example, when Professor Smith and I, another professor in Georgia, submitted our amicus brief, counsel of record is actually Professor Brown and Kyle Veld. I don't actually know Kyle, but because they've been admitted to the Supreme Court bar, which we have not yet. So that's kind of a distinction why you see counsel of record versus not. The question presented is here an amalgam of the issue that certiorari was set on and an issue that the court required the parties to brief, right? That being the standing issue. Description of the parties. These are all mandated, portions of the brief. Corporate disclosure statement. Why is there a corporate disclosure statement in there? What's the point of that? Let's go back to our first class. Well, our third class, our first sort of substantive. class after the PT experience. Back to the ethics issue.
Just if any of the justices have stock in some of the corporations that are involved.
Yeah, so a lot of this civil litigation is going to be involving corporations, and so this can actually be fairly important in terms of the judges deciding whether they need to recuse themselves from the case. Okay, the table of contents, obviously. This is actually important, and this is really useful, and I told you about not being particularly impressed by the headings, which doesn't matter a lot, but this is actually kind of the first impression of the substance of the brief, is the table of contents. And it is, for me, when I was working for the court and reading briefs, I went back to the table of contents a lot because it gives you that global overview of the arguments that they are and are not making. So it's actually quite important. Why is there a table, what is a table of authorities? And this is kind of antiquated, I think, in this day and age, but what's the table of authorities? Why is it there?
I think the cases they cite.
Yeah. And why is this here?
Like you could look at Rome, since Rome, the Ninth Circuit relied on Romer, you can look at Romer and then see all the pages it's on.
What did they have to say about Brown versus Board of Education? This is an index that's very useful in that sense. Of course, with the ability to search for terms and documents now, it's arguably kind of irrelevant, but it's still interesting. I mean, you can see a lot by looking at the table of authorities. For example, one of the things, you can't tell from the table of authorities, but from the brief, they're citing different cases than respondents are citing, okay? One of the most revealing things is what cases a party or court will cite for the standard of rational basis review. FCC versus Beach Communications, Heller versus Doe, that's the defendant. That's the government, typically, right? Defending the law. If you're citing Romer or Claiborne, one of these cases, Moreno, that's more typically a plaintiff's move because the application of rational basis there is a little bit more vigorous.
Passim is just throughout, right?
Sorry? Yes, that means it exactly. Passim, P-A-S-S-I-M means throughout.
That's that,
Okay. So, one of the things that I thought was really, I think the introduction here, the themes introduced in the introduction were pretty brilliant, honestly, in terms of, well, who are they speaking to? They're definitely speaking in the language of so-called conservative justices on the court, right? And let's identify some of the themes that petitioners raise here.
History, tradition.
Okay. So let's elaborate on that. So,
Marriage is like a block of our, like a traditional block of our society
Okay.
that's been here forever, and so we shouldn't change it now.
okay. So, marriage has a long history and tradition. And let's say, traditional marriage, right? Which we'll use as meaning heterosexual or opposite sex marriage. And why does that matter?
They argue that it matters because it's just like a pillar of our society. We can't just like change it just because we feel like it.
Okay.
I mean, also sets off like Prop 8 as just being a radical concept.
Or the same-sex marriage as being a radical concept.
Oh, yeah, sorry.
Okay. Okay. So it's not. By definition, it can't be irrational, right? And sort of by definition, it can't be animus. Of course, obviously, I'm really interested in how the parties are thinking about animus, what the court is going to have to say about animus. But and we talked a little bit about the different types of jurisdictions in the United States, right? So maybe you have one jurisdiction that since for 150 years has defined marriage as being between one man and one woman. And then let's say you have another state that it just said marriage is between two adults, and then in the past 5 years, it's enacted very aggressive legislation defining same-sex marriage out of marriage, refusing to recognize marriages from other, same-sex marriages from other states, etc. So if you have this traditional jurisdiction, and then you have, you know, what I call the defensive jurisdictions, it might be, if you think about animus as being a spite or ill will, it might be pretty easy to say it's here, right? You're gonna have this campaign literature, we don't want, much as there was in California, you know, we don't want our children being taught about homosexuality in schools, and, you know, a lot of contemporary action and rhetoric around the issue of same-sex marriage versus a traditional jurisdiction where this is just kind of, you know, it's always sort of been this way, right? What, do you guys see a difference in terms of the idea of animus as between those two scenarios?
I'm sorry, what is the DEF jurisdiction?
Defensive. I mean defensive in the sense of like someone getting defensive during an argument. Like they see same-sex marriage kind of bubbling up in society, and it's like, okay, no, we want to shut this down right now. Okay, so, you know, the one jurisdiction has just been a heterosexual definition of marriage since the state enacted its first marriage law, right? The other jurisdiction, there's been contemporary, affirmative legislative efforts around the issue.
And it is two different kind of concepts. It's like you're just trying to carry on as usual with a traditional jurisdiction, whereas defensive, it's like you're trying to squash an uprising.
Interesting. Okay. And so if you look at the subjective intent in each of these cases, it's different. Right? So if you think about animus as being related to subjective intent, it's sort of present in one case and really absent in the other. Okay?
But, I mean, couldn't you argue that even in the traditional cases or states, I just think that, you know, things change, and refusal to recognize that in itself is a kind of animus. So you can, you know, I mean, the argument can be it's traditional or whatever, but when our ideas about marriage or society changes, it's not, you know, I don't think it should be so inflexible, I guess.
So in a sense, the, you know, due to social change, the reasons for excluding are gone, right? And so something that was rational can become
well, I mean, who was to say that it was even thought of then when they said that, you know, between a man and woman?
It certainly
blah,
wasn't.
blah,
I mean, you know, the concept of the homosexual, quote unquote, you know, is of relatively recent vintage. So if we think about animus as subjective kind of malicious intent, it's going to be present in some of these jurisdictions, but not in others. But if we think of animus as something different, maybe, well, what is that? I mean, how are you thinking about animus in the scenario that you described? So it's not about the law was enacted to, you know, express hatred of gays. That's obviously not the case.
Yeah, no, I mean, it would be a lot more difficult to prove, but...
I think it's more about the definition.
Yeah.
Right? I mean, so you know, in this scenario, you're no longer claiming, oh, it's about malice at the time of the enactment of the law. What are you claiming? What is the problem?
Its continued enforcement is about malice.
Okay. So...
Or animus, I guess.
That's one idea? Okay.
Well, because, I mean, couldn't you make the argument that I'm just trying to think of, you know, at certain times in our history, other things have also become things that were, you know, traditionally thought of as acceptable, like loving or whatever, became no longer appropriate.
Okay. So there's always that, the race analog or the loving analog, right? I mean, we're working on forms of argumentation here, right? You sense that maybe there is something like animus, even in a traditional jurisdiction, but how do you sort of reason your way through that? Well, one is to have an analog, right? A race analog, a gender analog. You know, what might be a gender analog? A tradition that was around for, you know, hundreds of years, never was thought of as being expressing malice towards women, let's say.
Not having the right to vote.
Okay.
Like, that just is, if we just go with the status quo or tradition argument.
Okay. I mean, and I think that puts a really different lens on it, because the challenge with equal protection jurisprudence is dealing with the types of discrimination that feel very familiar, right? And saying, well, when is that fair and when is it unfair? How do we tell the difference between those two things? I mean, would it make sense to say, you know, in state A, it's permissible to refuse to recognize same-sex marriages, whereas in state B, it's impermissible? Is that a consistent, fair result? Maybe. I mean, marriage laws have always varied a lot by state. Then again, we wouldn't allow marriage laws to vary by state vis-a-vis miscegenation, anti-miscegenation laws. What else? You know, if you're looking at this question of, is the state A traditional jurisdiction type of discrimination an impermissible law as a general proposition under the Equal Protection Clause? What else, you know, besides alleging that it was enacted with malice, what else might you say, what might one argue is problematic about this law?
So absent malice, they don't, I mean, I don't buy their procreation.
Okay.
So they don't have a reason. So even with or without malice, they don't have a, whatever, if it's compelling interest or depending on the standard of, or the
Governmental interest, yeah.
Well, I think this is, so that's a great point. I think this is something that really comes out clearly in reading this brief. And I kind of want to just write a little blog post about this. You know, what is rational basis review, right? Traditional rational basis review, I feel like basically the state opens its mouth and says something, and that's good enough, right? So the traditional rational basis review, encouraging procreation within marriage, of course that's a legitimate state interest, right? Let's look at the lowest level of scrutiny. It is the classification, opposite sex versus same sex, rationally related? Of course it is. Of course it is.
I know that rational basis is like so low, like you said, the state says anything, but I
One type of rational basis is.
Right, like the traditional, not with the bite, as Chen calls it, but I don't understand, like, I just don't get the procreation argument at all, because it's not like a law that if a man and a woman, if the woman gets pregnant, they have to get married. I just don't get their logic.
So you were questioning the tailoring prong, which is really where the attack is gone.
I see no, yeah.
Okay, let's see if we can figure it out. Let's see if we can figure it out. So the law says marriage is a union of one man and one woman, period. What effect? So of course the California Supreme Court said the only effect was to exclude. But what are arguably the other effects?
Well, it includes
Yes, includes in what?
opposite sex marriages.
Okay. In fact, I mean, that's almost categorically true, right? If one of the effects is to exclude one group, then the other effect is to include opposite sex couples. Include them in what?
The marriage group.
Okay. And these are just kind of the core questions, right? What does that mean to be included in marriage? And I think this is an area in which the petitioners have kind of a tricky line to walk. Because if we're saying, well, we are incentivizing. We are incentivizing opposite-sex couples to get married so that when they get knocked up, I can't write that on the board, that's terrible, accidentally procreate, it'll be within marriage. That's the argument.
So they're saying that if they have this like inclusive thing that's not like tainted by
Yes.
same-sex couples, then if a man and a woman accidentally procreate, they'll get married?
They'll get married first. They'll get married first because marriage is so great and they want to be a part of it. Go ahead.
Like, what's the incentive to get married? If the law
Marriage is
doesn't really-
great. Didn't I just say that? Okay, there are two ways of looking at this. So basically, marriage in and of itself is great, right? It's special, it's meaningful, blah, blah, blah. The other, I would say more cynical, but I don't think it's cynical, is marriage is great, because it's exclusive, or maybe more specifically because it excludes same-sex couples. This is problematic, right? You're saying, well, the value of the institution is actually resting in its exclusion of the social group. That's probably pretty problematic. So what if you go with this idea, well, marriage is great. How does that affect other arguments by the petitioners?
So they're saying marriage is great, so men and so opposite sex couples will just get married because it's great. And
Right.
then if they accidentally get pregnant, they're married.
Yeah.
But then without the exclusionary component, why is any of that affected with same-sex couples getting married? Because same-sex couples are married and they're not going to accidentally procreate, but opposite-sex couples are married and they accidentally procreate and they're married, and so it's great.
Brutal. What you're saying is that they can't escape this implication.
Yeah.
They
so I
cannot
don't see
escape
it
the okay,
without it.
right. Because
I kind of agree with that because when I went back and looked at the district court fact findings.
Yeah.
It goes on for pages and pages about all the benefits of marriage for property, procreation, health, whatever, social behavior. And so I feel like it gets dangerous for them the more they say marriage is great because then it's like, well, then why can't everybody have that?
Yeah. And I think their argument that marriage is great, then it gets into the separate but equal when you start looking at domestic partnerships, is that marriage is great, but it's not equal then.
And they said that in their brief. They were like, well, same-sex couples have all of the benefits. They just can't use the word. So then, to me, it's the Brown argument.
it is a Brown argument at that point. And the lower courts treated that, I think, pretty blithely, honestly. It's like, of course, and the fact findings are there. Are they legislative or adjudicative? But, marriage is great. It has this unique, special meaning. And that's why having the same rights and benefits is not enough, okay? So you guys have pointed to this sort of, conundrum, I think, that is within petitioner's argument. But this is the rational basis claim. And this is a claim that the classification that accomplishes the exclusion is rationally related to the legitimate state interest of getting opposite-sex couples to get married. So that when they have this accident, because they're irresponsible, and that's really the crux of the argument, okay? And so the question is, I think under traditional rational basis review, the analysis kind of stops here, right? You don't do this deeper inquiry into, well, what exactly do you mean? How is it that the exclusion of opposite-sex couples same-sex couples incentivizes opposite-sex couples to get married? And you'll see that, the explanations, defenses, justifications for these laws don't really unpack this. Because that's when you start to get a little bit of trouble, where it really sounds like our old friend, invidious discrimination, which is, hard to say exactly what that is, but that's what the Equal Protection Clause is out to eliminate. Yes?
But for the incentivizes, by excluding the bottom one of
Yes.
that, how can you say, I mean, if it were a regular rational basis and it were to stop there, how can you say that that's a legitimate governmental interest?
The legitimate governmental interest is encouraging procreation to take place in marriage.
But what about people who think that marriage is less great because it is exclusionary, and so it's, I mean, they're not arguing that.
But we're not here to second guess
the rational.
right, the sort of the reasoning of the legislature. What rational basis review means is the key to this case, from a certain perspective.
Wait, but, sorry, I mean, I
Don't
think
be
that the
sorry.
district court made this argument, or said this too, but they're saying, so, excluding the rational basis, the bottom one, sorry,
Yeah.
my contacts are really messed up. So I
This
can't really
is
see
actually
you
quite
well.
far away, yeah.
But they're excluding them because of procreation, right? But, I mean, that in itself isn't legitimate. Because how does excluding same-sex couples equate to procreation? And I think the district court had said something that marriage has never been, or, it's not about procreation, or something like
So
that.
let's put it this way, and this is a great thing that they do in their brief. You raised a number of good issues. Let me see if I can capture them all. Sort of these ideas of agency, so judicial intervention, and the idea of invading privacy versus bestowing state recognition. The notion, the sort of idea of hands-off procreation, right? That comes from cases about the state invading people's privacy, their liberty, trying to control what they do around procreation. It's really different if the government wants to say, we are going to offer you this bonus for doing what we want. Okay? And so another way of looking at this question is not,
So like a positive or negative liberty?
that's definitely part of the difference. Absolutely. The petitioners talk about this has nothing to do with the right to be let alone. It's demanding government recognition, which is very different than saying, government, get out of my bedroom or whatever. But, so let's say you're the government. You know that opposite-sex couples can have kids accidentally. And so you say, you know what? It's not a perfect solution, but I want to deal with this. And the way I want to deal with this is I want to create this little bonus package called marriage. And I get to decide which groups I include in that and which groups I don't. And to me, it makes sense to include, I don't have to include everybody. As the state legislature, I get to decide between groups I think it makes sense to include. I think it makes sense to include opposite-sex couples because there is a correlation, and that's undeniable, right? That's biological fact. It's another big theme, important theme in the brief. There's a correlation between being a member of an opposite-sex couple and being able to procreate accidentally. It's not a perfect correlation, it's not a perfect fit, doesn't have to be under rational basis review.
But wouldn't that just go to the biology, not necessarily whether they're married or not? I mean, couldn't any opposite-sex couple, whether they've been together for one evening or 10 years?
Right, so that's why you want to dangle this carrot out there. Okay, opposite-sex couples, we have this great thing called marriage, we really encourage you to participate so that there's some chance that when you get knocked up, you'll actually be married. It's a really different way of thinking about what this law is doing. Yeah.
I mean, I can see under rational basis review, I can see it being constitutional almost. I mean, just because
Oh yeah, it's
legitimate
clearly
state interest.
constitutional under traditional rational basis review.
Yeah. And so what I'm kind of like worried about here is, what I'm thinking of is, a lot of the reviewing of the preceding courts have said, it fails rational basis review and kind of established it down there. But then they've kind of touched on other standards of review. And if their basis for making it unconstitutional comes down to rational basis review each time, even though they're touching on the others, it's like once it gets to the Supreme Court, the Supreme Court's probably going to continue with a rational basis review instead of define.
Who knows?
Another standard review.
So some of the lower courts, and some of it in Prop 8 and also the DOMA litigation, they are recognizing Professor Chen's other category of rational basis review with bite. They're saying, well, and they're following Justice O'Connor and her concurrence in Lawrence, who said, we exhibit additional concern when there's a disfavored group being punished by the laws. Okay, so she's acknowledging the existence of this thing, right? Rational basis with bite. And then other courts have also seized onto it. Maybe the Supreme Court will acknowledge this.
What's her name?
Justice O'Connor?
Oh, sorry, I didn't know who you said. I just heard you say she, so I didn't know.
Yeah. So
Okay.
Justice O'Connor and her really interesting concurrence to Lawrence v. Texas, says, and she cites what I call the Animus cases, there is this other level of concern when you have an unpopular minority.
She doesn't call it rational basis with a bite.
No.
She just kind of talks about it.
No, I don't remember exactly the language she uses. I mean, it's along the lines of what I've been saying, but it's about sort of extra concern, right?
And so that applies to a minority that's unfavorable? Is that how you describe it?
Unpopular.
Unpopular?
Disfavored, that kind of idea. Which is sort of like, well, we, kind of eyeballing, they're sort of like a suspect class, but we're not going to go through all that. We're just going to say they're an unpopular, disfavored group. We'll be a little more concerned. The court enshrining a fourth level of scrutiny, I don't see it happening. I think they need to come up. This is the great thing about this case, too. It's not just about same-sex marriage, it's about equal protection law and what direction the court's going to take. Is it going to stick with this system that's kind of crumbling and falling apart, or is it going to try to either tinker with it, add a little bit to it, or actually rationalize it, which they probably won't do. That's too radical, for a court to undertake a full sort of rationalization of this entire body of law. But it would be interesting if they did that.
And so if they did it, if they said it was sexual orientation or gender or sex, it would be intermediate?
Gender is a recognized quasi-suspect
Intermediate, right.
classification, so it would be intermediate.
Okay.
Except there is the reason it's quasi-suspect and not suspect, and the reason it's intermediate scrutiny and not strict scrutiny, is it's sometimes okay to discriminate on the basis of gender when it's based in real differences between men and women. So that, petitioners weren't addressing that idea when they brought up this biological fact theme, but it's relevant if the court does see this as gender discrimination. Sexual orientation has, up until the recent DOMA case has been, the Ninth Circuit case, high-tech gays, said sexual orientation, it looked at the question. Sexual orientation is not a suspect classification because sexual orientation is conduct, chosen conduct, not an immutable trait. Okay, so that's the state of the law.
What case is that?
It's the Ninth Circuit high-tech gays. It's the greatest case ever.
I was
High-tech
wondering,
gays
like,
versus
what?
disco. Disco is the defense investigative service something. But it's basically, this affinity group of folks who were gay, who had also tried to get security clearances to work for the federal government. And the federal government said, if you're gay, you are at risk for blackmail. And so we're not going to give you these security clearances.
What year was that? I'm just curious.
No, I just wish I could remember off the top of my head. I want to say it's the early 90s.
But
I know one of you can look it up real quick. So
hasn't I don't know if this is me just maybe making this up, but hasn't it been found that it's not a conduct choice or that it could be a biological fact?
So,
I mean, I don't think
There's
the Supreme Court would
evidence-
say that because I think that would be way extreme for them, but.
I think, so to me, it's the idea of the Supreme Court or any court deciding whether sexual orientation for straight people, for gay people, bisexuals, whatever, saying it's a matter of law, that it's immutable or not, I find incredibly offensive. Like, that is not within the competence of the judiciary as far as I'm concerned, right?
Mm-hmm.
But it's exactly the question that's posed by traditional suspect classification analysis. So at the time of high-tech gays, if you guys, if you want to look at that decision, it's a really interesting one. The Ninth Circuit, I honestly think there's not a citation for this. That the Ninth Circuit simply states that sexual orientation is a matter of conduct versus an immutable trait. And again, if somebody wants to pull up the case and we can kind of plow through it, just if you search for immutable or the first letters of that, we can find the passage.
It's 1990.
1990. Right. There's been a lot of debate, obviously, since then in the scientific community, in the political community, about whether sexual orientation is status or conduct, right? And I mean, that's why sexual orientation is such an interesting lens through which to look at equal protection law. Because it's not just that what does status conduct really mean? Status is like, it's accident of birth. I can't control it. I'm innocent. There's this whole sort of theme of innocence, right, around the idea of something being a status versus a conduct. That I think should not, and I'm just talking about my views, but should not be a basis for equal protection decisions.
But then you couldn't get to really being a quasi-suspect class unless you address that.
Well, okay.
Under the gender analysis.
Okay. So
this is actually something that came to mind for me too, because I think I'm just getting too bogged down on the findings of fact in the district court decision when I was trying to summarize it. But the district court pretty much conclusively says that sexual orientation is an immutable trait. Basically that, most people are born that way, which to me almost was a little bit extreme because it kind of foreclosed the possibility that you just.
It forecloses an agency.
Yeah.
Right? I mean, there is something offensive about saying sexual orientation is a choice, and there's something offensive about saying it's not a choice. And again, I think it's beyond judicial competence. It shouldn't be addressed, but that is, so to kind of get these two ideas together.
I have the immutable language whenever you're ready.
Can you, go ahead.
So it says homosexuality is not an immutable characteristic. It's behavioral, and hence is fundamentally different from traits such as race, gender, or alienage, which define already existing suspect and quasi-suspect classes.
So, right, because gender's not this whole idea of gender being a performance then now is also really pushing at that idea. And you go back to Plessy. Race is a performance in a sense, right? There's some choice involved with racial identification, right? But there's this belief in the sort of blackness and whiteness of these categories that you see in the decisions. Is there a citation to that? Is there a footnote or a citation?
Accord Woodward. So Woodward is
But they're citing a case, but they're not citing evidence
right.
as to whether sexual orientation is immutable versus behavioral.
And all Woodward is saying that race and those other, it's only talking about those other ones.
So that very idea that the court can make a proclamation like that and not have to explain it or ground it in evidence, again, we talk about ethical judicial opinion writing, that to me is problematic on a formal level. On a formal level, you're making a claim about social reality, about identity, about humanity, and there's no citation for it, right? Okay. Okay, so suspect classification analysis, and since you have the case up, if you could just make sure I'm getting these all correct. I'm writing this article about suspect classification analysis. I'm kind of immersing myself in this stuff right now. Discrete and insular minority, politically powerless, history of discrimination, mutable trait. And relationship to ability.
I don't even say relationship to ability.
It's
Is
so.
that are they sometimes?
So, all right, so I'll give you guys my like short story, and if I've said this before, please stop me. A lot of like my scholarship, this Amicus Brief, this class are all kind of, you know, resonating with each other, which is great, but I don't want to repeat myself to you guys. You guys know where the suspect classification analysis originated, remember?
Footnote and what was it, Carolyn?
Carolyn Products footnote 4, you remember the pressing equal protection issue in that case?
No.
Spilled milk, okay?
Oh, yeah.
Adulterated milk products, like woof, burning with justice, right? And you guys remember from ethical judicial opinion writing, Carolyn Products footnote 4 was drafted by whom?
Law clerk.
A law clerk, okay? And all it's, you know, so the whole case is about this, you know, very deferential review, deference to the legislature, and then footnote 4 says, but sometimes we might want to show more judicial scrutiny, use more judicial scrutiny. If you have laws that are discriminating against racial minorities or religious minorities, things that interfere with the political process, etc. 1938, footnote, in a filled milk case. And this is the foundation of contemporary equal protection jurisprudence. Okay? So, not mentioned again, really not, the idea of suspect classification analysis doesn't really become fully formed until 1971. In a case called Graham. And then by 1973, in San Antonio School District versus Rodriguez, the court refers to these as traditional indicia of suspectness. So pretty quickly evolving tradition. Okay. And then 1977, the canon, you know, again, according to Kenji Yoshino, others, the canon is closed.
What case was that in 77?
It was an illegitimacy case, and it was not waiver. I'm not pulling it up right now. I find this fascinating. Okay, I mean, very, you know, obscure origins, very sudden, you know, rise to this sort of superstar status, and then, you know.
Yeah, only a decade of cases and precedent, really. Yeah, it is kind of odd that it exists. I mean, would you say it's hard
Well,
to become art?
that's sort of, yeah, the narrative I'm working on. Yeah, go ahead.
Well, I mean, would you say it's like kind of a weaker argument just because it's like not so rooted or grounded in
Thought, for example?
thought or history or anything?
Yeah, that's kind of the point of my article. But so everyone sort of started glomming onto this. They're like, oh, I'm a suspect class, I'm a suspect class. And it became legitimized through that process of people wanting to use this as a lever to heighten scrutiny.
But hasn't the court not really recognized it though since
1977, yeah.
So in high-tech case, they don't have discrete and insular minority, and they don't have relationship to ability.
Yes,
They
good.
just have the other three.
Okay, so this really comes to the fore. So it's in Claiborne. It's in the gender cases, and also in Claiborne, which was before high-tech gays, but which is to say, the sort of traditional indicia of suspectness. You know, it's not this rational, consistent test necessarily. So, in terms of looking at sexual orientation as a suspect classification, you could say it turns on the immutability question, but it also depends on which of these factors the court gives the most weight. This is becoming disfavored. This, I would say, is receiving more emphasis. The example of women kind of disrupts the first criterion. Okay? This is an important question. And again, I don't see why being politically powerless. I mean, there's a certain theory. So Justice Scalia had this great quote in his dissent to United States versus Virginia. And he said, I'll just paraphrase it. He said, people, so of course there's a history of discrimination against women because people of earlier eras had biases. And we have biases today too. We just don't know what they are. And you know that's my belief as well, that we're all steeped in contemporary biases. We don't know what they are, which ones are fair, which ones are unfair, and that's part of the job of equal protection analysis is to sort those out. But his contention was, that's what's so great about the democratic process. Yes, we have biases, but there's the rough and tumble democratic process and it all gets sorted out, right? Whereas other people think, well, no, it's actually the job of the judiciary to intervene when those biases come up, because when you have a marginalized group, especially if they're minority, that don't have political or economic power, they can't participate sufficiently in that democratic process to sort those biases out. So one sort of reinterpretation of Caroline Product's footnote 4 was that it was all about political powerlessness or interference with the political process. From my perspective, I think this underestimates the extent to which laws can create groups as marginalized, can create them as politically powerless, can create them as despised, right? So, you know, do you always look to the past to see who's politically powerless, who's suffered a history of discrimination, or do you focus more on what is the law doing to this group of people that it's classifying? It's kind of the big abstract question. But these are the suspect classification analysis factors. The real issue, I think, is how the court glosses it and which factors it considers more important. And, you know, our friend Bill Eskridge says that suspect classifications are not acknowledged when they are politically powerless. They're acknowledged when they've achieved enough political power to get noticed. And he says that's where gays and lesbians are right now. And he says sexual orientation will be recognized as a suspect classification in the context of the marriage equality cases. That is his prediction.
Did you say what level?
Suspect.
So that would be strict scrutiny?
Yep.
Okay.
Well, wasn't that one of the issues in Cleburne too, because it was it handicapped people?
Yep. Yep.
And didn't the court say that actually they have lots of political power because there's tons and tons of groups that are like lobbying on their behalf, and so that factor actually worked against them?
These are great questions. Okay. So, and just the one thing, other thing I want to throw out, results of 2012 election. What impact does that have on this inquiry? There's a lot of positive results for LGBT folks in that election. So political power.
I like Cleburne because that's where my husband's family's from. So.
Oh, that's great. Is it Cleburne? I'll never change how I pronounce it, but is it Cleburne?
Oh,
Not
yeah.
Cleburne? Okay.
Oh, yeah. But
no, it's okay.
Cleburne?
I mispronounce many things. Sorry. I have my own vernacular. Let's put it that way. Political power. Okay. So City of Cleburne versus Cleburne Living Center. The existence of protective legislation means what?
that you have political power. You're not lacking political power.
Yep. And, boy, I want to get this exactly right, but I believe it's Frontiero. The same thing means you don't have political power, right? And in Frontiero, you also looking at office holders. So this is irrational, right? This doesn't make any sense. Suspect classification analysis really doesn't make any sense, you know, from a certain perspective. You know, will the court even look at suspect classification analysis? Will it avoid it? If it looks at it, which of these factors is it going to focus on? Whichever factor it focuses on, what's it going to find? I think there's too much change happening in terms of political power, social acceptance in the LGBT community to properly say it's a suspect classification in a certain sense, if you focus on that particular criterion. Okay. But that also raises another theme I thought was really well played out in the brief. The idea of the democratic process and also state sovereignty. I mean, this is a different brief than would have been filed 20 years ago, or 30 years ago. You know, 20 years ago would have been, you know, it's appropriate to disapprove of homosexuals. These arguments are really different. But, you know, the court, rather the petitioners are emphasizing the fact that this is Justice Scalia's position as well. This is the kind of issue you want to let people debate about. That idea of debate, right? That's on the first page. And figure it out over time. You know, it's you know, in 50 years, a same-sex marriage is allowed in every state. Would you rather have it happen through the democratic process or by judicial fiat?
So Claiborne and Frontier are talking about like protective legislation. So like Allison was saying, like for handicapped people, there's like organizations and
Right.
nonprofits. But if we're talking about democratic process, then we're just talking about, you know, each person has a vote. So the minority versus majority. That if we're just going to assume that.
Well, do you remember the one by Justice Scalia in dissent to Bromberg calling gays and lesbians a politically powerful minority, because of course, you know, money is speech in our society, and the bare fact of being a minority doesn't necessarily correlate with being politically powerless. And the same, the obverse or whatever, with women, not a minority, but still, politically powerless quasi-suspect classification. Okay, this is great. This is really good stuff. This is really helpful to me with, you know, what I'm thinking about too. Let's talk about the idea of democracy and debate. Is there a debate going on about same-sex couples, families headed by same-sex couples, you know, same-sex marriage?
Yeah.
Okay. So why should the courts get involved?
Constitutional protections.
Okay. Do the courts have a special role there?
Yeah, I mean, throughout history, states have enacted laws that were found to be unconstitutional, you know, outside the power of the federal constitution or their states even.
So, even if you have the well-functioning political democratic process, there's still a role for the courts.
Yeah, it's a checks and balance, kind of separation of powers. It's like, we don't want unconstitutional laws being created even though they represent the majority.
Okay. So and that's a sort of philosophical point of distinction in terms of the role of the judiciary, right? Is the judiciary there to cut, you know, call balls and strikes, or something else? What you're saying is to look out for minorities, for groups that might be unfairly disadvantaged by the democratic process, right? And there's the people who subscribe to one view versus the other. When does the court have license to get involved in, you know, otherwise democratically created piece of legislation? And what is it? And these are sort of the values that are animating equal protection jurisprudence, right? Like, what's the
that's
trigger for the judiciary getting involved?
The standing issue. I mean, as soon as there's like injury, concrete facts, and the third realm, redressability, I guess, like, then they have, it's access to the courts. I mean, courts is like that, it's supposed to be the one thing that anyone has access to. So if they feel they have been wronged, it's not like the court system is raising this whole case sua sponte on their own.
Right.
You know, it's like there's people that feel like they've legitimately been wronged, and so the court's there to decide yes or no.
Okay. Of course, there's so many barriers to entry to the courts, right? I mean, even beyond money, you know, does the ACLU think you have a strong case that they'll be willing to litigate it for you or what have you? But so there's that idea that as a threshold matter, the judiciary will get involved if someone can prove a harm, right? Can prove an injury, which is very interesting in the affirmative action case because the plaintiff there, Abigail Fisher, would not have been admitted to UT even in the absence of their affirmative action policy. And so there was a question, they explored this at oral arguments as to whether she actually had standing. And the idea there is that being subject to an unfairly discriminatory process is a sufficient injury in and of itself to establish standing. But so once you put your claim in front of the court, I mean, what is the trigger for saying we don't trust the democratic process here? We don't trust the majoritarian process. Right? I mean, why shouldn't the court look at this and say, wow, this is a really dynamic, evolving social issue, hands off?
So I actually find this to be a really interesting part of the whole debate, whether a voter-driven initiative and a legislatively created law like deserve the same amount of deference. And I was just trying to find a portion of the trial court decision that talks about it. And he says, let's see, an initiative measure adopted by voters deserves great respect. When challenged, however, the voters' determinations must find at least some support and evidence. This is especially so when those determinations enact into law classifications of persons. So I feel like here, maybe this is slightly more eligible for judicial review than something the legislature just put out on its own because voter-driven initiatives can potentially be a subject of animus a little bit easier than the legislature.
I think there's a recurring theme with you of thinking that people
I'm
are just really evil.
don't trust voters like for this kind of stuff. Well, also, I mean, I know we talked about this before, but also the legislature has to put out, you know, crazy findings of fact and things like that.
But they don't.
Justifications.
They don't.
Admin is just haunting me.
Yeah, no, that's really interesting because I did a little work in progress with Professor Lynch from the clinic, and he was talking about regulatory review and stuff like that, and findings and deference in that context. It's really different in constitutional law and rational basis review. Okay, this is key. Okay, key characteristics of traditional rational basis review, and of course petitioners emphasize this. Legitimate state interest could be almost anything. Rationally related could be almost anything. They don't even have to have a legislative record that supports it. The court can speculate as to the reasons why they might have enacted it. And if they can find one legitimate speculative reason, that's good enough. You're shaking your head, Alexis.
I don't know.
But I think that eviscerates judicial review, and I think whenever there's a classification of persons, review shouldn't be that deferential. But so you were saying show less deference to voters because mob mentality.
Yeah. Well, and I think that's one of the reasons that the district court judge goes into the findings of fact, because he says the factual record for this is the campaign literature. The campaign literature, you know, shows animus to a certain extent, or, you know.
I think it should apply here too, personally. I mean, you know, is it really that different? But there's an argument for more deference when it's a straight up voter initiative, which is what? Direct democracy.
Because at least it's represented. It's direct as opposed to republic.
I definitely
both are
get
subject
that.
to animus. I mean, both are just.
I get that, but
That this is more of a concern.
yeah, for something like this, like I think what he says about it, creating classifications of people, particularly if it happens to be a disabled.
I think this is a fascinating question. And again, it's kind of emerging as really central to this article.
If
Is
it was
there
like-
any place for this extreme deference? As soon as you have a classification of persons, aren't we in a different territory? I think so.
You know, like I think, okay, so if it's a voter-driven initiative to put like a stop sign at a busy intersection for safety, like fine, difference, direct democracy, but like that's not ostracizing anybody, and so.
So the fact of there being a facial classification of persons is almost in and of itself suggestive that there's some kind of majority trying to get the best of the minority in that situation. That's a pretty good argument for less deference in those situations. And I think also in legislative enactments as well. So we've had a pretty free-ranging, and I think really excellent philosophical discussion about this. You know, thinking about this from the perspective of writing, we're in this brainstorming phase, right? Thinking about themes, arguments. But if we don't nail it down, this is overwhelming. Right? You can't just start thinking about, oh, I'm going to write an opinion based on this biological fact idea. It's too unstructured, right? So I want you guys to keep going forward with the task of mapping out all the raw materials, all the sources that you have, and thinking about the structure that you're going to use. And the themes will come in, you know, but you want to start with structure, with doctrine, and then let the themes sort of animate it, not the other way around. Because it's just too amorphous and sort of overwhelming to try to write that way. So on Wednesday, let's maybe try to do a very brief outline of both of the briefs. And then the week after that, you guys are coming to me with an outline of your opinion. So I think we want to talk about in class, I'm inclined to look at this argument. I'm inclined to base my analysis somewhat after this case. Okay? Okay, great. I've really learned a lot from talking with you guys about this stuff, so thank you.
What's involved with like a dormant commerce clause?
Fairly products?
Well,
Or sorry, what was
dormant commerce clause? Like
dormant commerce clause?
Yeah, what's in that realm?
What's that about?
I'm gonna go back and revisit that one.
Okay.
That's how I see where this is almost developing, because it's like, if you have if it's gonna be a state by state that can enact laws based on allowing same-sex marriages or not, it's like, I mean, you're gonna have fluctuation of people, like, you're gonna be crossing that. Like,
So
that's
that's really a whole faith and credit issue, right? And this is where the intersection of the DOMA case and property case becomes really, really interesting. So we can talk about that a little bit more on Wednesday.
Because I have to look at more of the like state sovereignty.
Well, the idea of state, see you guys later, thanks a lot. The idea of state sovereignty really resonates in so many different parts of the Constitution, right? Because with with the Commerce Clause, it's like Congress only has the power to do what it's authorized to do. And the question then is, well, what becomes a realm of state control versus a realm of federal control, if there's some overlap. And then you also have like preemption issues and all of that. But I think, like I said,
you would argue, marriage is something that's only been regulated on a state by state basis.
Well, that's why I think DOMA, I could totally see DOMA goes down, probate stays up, or at least the rhetoric in the two cases kind of is the same but has different implications. The feds don't belong in the business of regulating marriage, and the state should be a laboratory of experimentation.
Right.
I've been trying to think through actually DOMA Commerce Clause stuff too, and I started thinking about like the property aspect of marriage and fostering easy transitions and purchases of property? And like, could it be that some states not allowing same-sex couples to get married and then have the same property protections as married couples? Like, could that negatively